back to IMD Corporate's Business Insights series. I am Adriana Balmos and joined once again by Olexandr Kyrychenko, partner with IMD Corporate and an expert in corporate and commercial law. Hello, Alexander. It's great to have you again.
Hello, Adriana. Thank you.
In our last episode, we explored the complexities of regulatory compliance for businesses. Today, we shift our focus to another topic, intellectual property rights protection. Alexander, please tell us more about how businesses can safeguard their innovations, brands, and designs to maintain a competitive edge.
So, of course, Adriana. So let's start with trademarks. Now, trademarks are protections of your brand name, your logo, your slogan, your tagline. There are, of course, limitations as to what can be trademarked. However, that is the overview of what it is. Now, it's critical to consider trademarks from the outset. And the reasons are twofold. Firstly, you want to ensure that you're not infringing on anyone else's trademark, as this can lead to costly litigation and compensation payments and wasted valuable startup costs, which have been spent on building up goodwill. Secondly, you want to ensure that the goodwill you do build is protected and no one else is able to utilize the goodwill from your brand name or your distinctive tagline. It's important to note that even if you hold a trademark protection in other countries, this will not necessarily protect you in the UK. As such, it is critical that any trademark is registered with the UK Intellectual Property Office. Whilst the temptation may be to register a trademark across as many categories as possible to cast a wide net, the Supreme Court has recently rolled back protections, and indeed doing so could put your trademark at an unnecessary risk. Therefore, it's important to think about which categories your company will trade in and may trade in the near future, and look to secure protection in those particular categories without casting the net too wide. Now, whilst trademarks are registrable in the UK, unlike some other jurisdictions, the US in particular, copyright, which is another intellectual property right, is not registrable, and instead it arises automatically. Now, essentially, copyright is an automatic protection to the benefit of the author of original works. Of particular importance is that copyright applies to software and the code written to develop the software. It's important to ensure that you seek legal advice from a copyright lawyer, and we have a very good team of intellectual property lawyers here. And in particular, you will need this if swathes of code were from open sources, or if your software uses a platform such as ChatGPT, as copyright protection of your product, your software, would be or may be more limited. In any event, it is critical to establish when the copyright arose and in who it vests. For example, if one of the company's founders wrote the software or the code before the company is formed, the copyright may well vest in that individual rather than the company itself. You will therefore need to ensure that you formally assign the copyright to the company. Now, this can be done as part of the joint venture agreement or the shareholders agreement, or even better, in conjunction with a separate copyright assignment document. Similarly, where copyright is produced by contractors in particular and employees to a lesser extent, the company's ownership of copyright could be called into question. And it is very important to ensure that you have adequate contracts in place, and any services agreements, consultancy agreements, director agreements, employment contracts provide for any copyright being created whilst performing services under those agreements to be vesting in the company itself.
What are patents and why are they important?
Well, patents protect inventions that are needed and involve an inventive step and are capable of industrial application. And these can also include a process, not just a product. Whilst the process of registering a patent is costly and detailed, it is absolutely crucial to ensure that any invention that is capable of patent protection is so patented and the protection is obtained, and that it is done at the earliest possible opportunity. It's important to bear in mind that on occasion it requires more than one application to the UK Intellectual Property Office and approaching the application from different angles, which could drive the costs. However, once application is lodged, and in particular once registration is complete, you will have an effective monopoly on your invention and your investment, preventing others from making, using, selling it without your permission or without paying you royalties for doing so. Now, data security is crucial here, as patents and inventions which are capable of being patented must be kept secret until the application is filed. A disclosure can have a drastically negative effect on your application. And the need to keep any patent secret brings me on to trade secrets. While this may not be an intellectual property right in sense that most understand it, confidential business information, such as the formula, processes, and procedures, can give you a competitive edge and must be protected. Now, typically, this is done by virtue of confidentiality clauses and founders' agreements, shareholders' agreements, or employment agreements. In addition, the use of non-disclosure agreements can be made. However, these in particular should be executed in accordance with best practice and with strict adherence to legal requirements in order to ensure that these are indeed effective and enforceable, in particular as there does appear to be a push toward back NDAs. Now, various confidentiality agreements are a great way to protect this confidential information and trade secrets that cannot be patented or trademarked.
Finally, let's touch on design rights. How do businesses benefit from them, and what do those protect?
Yes, of course. So it is possible to apply to register for protection of the visual design of the product, including its shape, its texture, and its ornamentation. Now, this protection would last for 25 years, subject to renewal every 5 years. Now, this provides strong protection to your product's design, as you can take legal action against infringement, and you will have exclusive rights to use that design and prevent others from copying it. Now, whilst some design requires registration, unregistered design rights could arise automatically. Now, these typically protect the shape or configuration of the product, but not necessarily the surface decoration of it. This includes 3D designs, such as shape of a chair or a product's layout. Whilst unregistered design rights automatically arise, these do offer a more limited protection and considerably more difficult enforcement approach than registered design rights. However, not all design rights can, of course, be registered. And it's important to note that for both registered and unregistered design rights, the design must be new, i.e. must not have been previously disclosed, and it must have individual character, meaning that it must differ from existing designs in a way that gives it a different overall impression.
That concludes today's episode on intellectual property rights protection. Thank you, Olexandr. From trademarks to design rights, we've covered the essential tools you need to protect your business assets and ideas. And in our next session, we'll discuss legal considerations when raising capital. To learn more about all these insights, Stay updated following us on social media and visit our website. Thank you for joining us, and we'll see you in the next episode.
Thank you, and we'll see you in our final episode next time.